Major breaking news out of the United States Court of Appeals for the Fifth Circuit down there in Louisiana and Texas. The ATF and the Department of Justice under Kamala Harris and Joe Biden is about getting ready to get spanked, big time spanked, in a case involving young adults and their Second Amendment rights. Great news for the Second Amendment. It may be on its way to the U.S. Supreme Court this term. Let's talk all about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks by Hamas on Israel Teach We Americans About the Right to Bear Arms. Check it out on Amazon. All right, folks, breaking news today. Major oral argument in the U.S. Court of Appeals for the Fifth Circuit down there in New Orleans, Louisiana, Texas, those states down there. Pretty favorable court for the Second Amendment. This is a case in dealing with whether or not federal gun control law, statutory rules, and regulations that prevent 18, 19, and 20-year-olds from being able to buy from an FFL, handguns and ammunition, and the like. This is a constitutional challenge under the Second Amendment. There had previously been an oral argument in this case of Reese, and the name of the case is Reese versus the ATF. And it was pretty clear in that three-judge panel many months ago that the ATF was going to lose. The DOJ was going to lose, and the Second Amendment was going to prevail. Between that oral argument date and today, the Supreme Court decided the Rahimi case, which really has no bearing on this issue. Nevertheless, it's pretty clear to me that the Fifth Circuit three-judge panel wanted to make sure they got it right, because they're going to, in my view, strike down this federal statute as being unconstitutional under the Second Amendment, and they want to make sure that the U.S. Supreme Court has no reason not to take this case. Because to me, it is a layup, slam dunk case that 18, 19, and 20-year-olds have the right to keep and bear arms, no different than a 40-year-old man or anyone else in America that's a full-blown citizen. I think it's a pretty easy case for the Second Amendment community to win. And the question is, which is the vehicle to win before the U.S. Supreme Court? And right now, there's two options as I see it. There's this Reese case in the Fifth Circuit that was just argued. And there's the lower case out of Pennsylvania dealing with the state issue, state of Pennsylvania rule associated with 18, 19, and 20-year-olds being able to carry or not be allowed to carry under certain circumstances. That case, the lower case out of the Third Circuit, is pending on a cert petition right now. It's going to be conferenced in October. But I don't think that's the best vehicle for the Second Amendment to win this issue. I think we're much better off in winning the Reese case. Now, where do we stand? So oral argument took place today with the specific question of, did the U.S. Supreme Court's decision in Rahimi that came out in June of 2024 somehow implicate or change or alter anything associated with the prior oral argument and the prior briefing in the Reese case dealing with 18, 19, and 20-year-olds and whether or not they have full-blown Second Amendment rights? Well, based upon this oral argument, it's pretty clear to me that this three-judge panel totally gets it. They understood that, as I've explained to you before, Rahimi was simply a routine application, if you will, of the text first, history second approach of Heller and Bruin, and nothing about the Rahimi case altered that text first and historical tradition rule second. Nothing altered it. Rahimi did not change the methodology, which means that the same methodology that the court considered in the Fifth Circuit prior to June of 2024, they're going to apply that same methodology. It's also pretty clear that at least two judges, and I suspect all three, but we'll see, at least two judges correctly understand that founding era militia laws, which we've talked about before, the Militia Act of 1792, plays an analysis or plays a role in establishing that at a minimum, 18, 19, and 20-year-olds are part of the people, and they are part of the people that have the right to keep and bear arms, because as I may remind you, in the year of our Lord 1791, the Bill of Rights went into effect. And then a year later, in the year of our Lord 1792, Congress passed the Militia Act of 1792. And in there it says that 18, 19, and 20-year-olds, basically 18-year-old males up until the age of 45, have an obligation to be in the militia And as a consequence of that, they have an obligation to bring with them, and listen carefully to this, they have an obligation to bring with them their privately owned firearms, their privately owned ammunition, their privately owned powder, and so on. Well, how is it conceivably possible that 18 and 19 and 20-year-olds had a legal duty under the Militia Act of 1792 that applied to all American males in the United States at the time? How is it conceivable that they would have an obligation to bring with them to militia musters their own firearms, their own ammunition, their own weapon systems, if they did not have a right and the ability to acquire them in the first place? Makes no sense. Beyond that, of course, we know that with the adoption of the 26th Amendment, 18, 19, and 20-year-olds today have full-blown rights to vote. So again, even if you want to assume arguendo, that at the time of our founding when the Second Amendment was adopted, 18, 19, and 20-year-olds are somehow minors and not entitled to the right to keep and bear arms, that will have changed because the societal changes contemplated in some instances by Bruin now contemplate that 18, 19, and 20-year-olds today are no longer minors by any stretch of the imagination. They can have sex change operations. They can enter into contracts. They can have abortions. They can get married. They can enter into jobs. They can move. They can do whatever they want once they hit 18. So even if you want to assume, which is kind of the DOJ argument, that 18, 19, and 20-year-olds are, minors or didn't have full-blown rights, and therefore today you can deny them Second Amendment rights, it's not going to fly anymore, even assuming that theory was true. But I think that theory is just blown up entirely by the Militia Act of 1792 that said that 18, 19, and 20-year-olds had a duty to bring their own firearms and ammo. And, of course, that means they had the option and ability to acquire them in the first place, because you can't force someone to bring something they're not able to acquire. And how would they be able to acquire guns and ammo if they didn't have the right to do so in the first place? So this should be a slam dunk win for the Second Amendment. I think the panel indicated that is also the case. The other interesting thing that came out, and we've talked a little bit about the role of 19th century laws, as you understand the second part or the second component of the Heller-Bruin methodology, look to the historical tradition of firearms regulations to see if there's one that's analogous that would justify a modern-day gun control law. And we know that there's a debate, as I've written about in the Harvard Journal of Law and Public Policy, whether or not the year to look at is 1791, when the Second Amendment was adopted, or you look at the year 1868, which is when the 14th Amendment was adopted after the Civil War. And through that is how the Bill of Rights gets incorporated and applied against the states. Now here, what's quite interesting is because, this is why I like the Reese case so much over the Laura case, the Reese case is against the federal government. The federal government does not have the option or ability to argue that the 14th Amendment matters here, because the Second Amendment has always applied to the federal government. So even if you want to argue that as to the states, which I think is a bad argument, let's assume you want to argue that as applied to the states, the 14th Amendment controls how you interpret the Second Amendment because it incorporates the Second Amendment and applies it to the states in the late 19th century, which I don't think is correct, and I don't think the Supreme Court will agree with that. They never have in other cases. But set that issue aside. That argument is not available to the federal government because, again, the federal government has always been restricted by the Second Amendment because it was specifically designed and applied originally to the federal government and to restrict the ability of the federal government to do things against those rights articulated in the Bill of Rights. But with that said, this panel really did indicate that as far as they're concerned, post-ratification or post-founding history, if you will, after 1791, can only be used as a confirmatory analytic, which means it can confirm the text in the founding history as being relevant, but it cannot go the other way. In other words, late 19th century historical laws are a one-way ratchet in favor of freedom, in favor of the text of the Second Amendment, but to the extent that the text of the Second Amendment and late 19th century historical laws are inconsistent, meaning there's more gun control laws in the late 19th century than there were in the 18th century, those must be rejected, which is what we've talked about in the context of the First Amendment, by the way, the Espinoza versus Montana case, which is a First Amendment case dealing with the establishment of religion and the free exercise of religion, one of the religious clauses. And Chief Justice John Roberts, in writing that opinion in Espinoza, specifically rejected, and this is important to know this, lawyers out there, Chief Justice John Roberts in Espinoza rejected 30. Hear what I just said? 30 state laws that prevented the use of monies to go to religious schools in the late 19th century. And the reason why Chief Justice John Roberts rejected those 30 state laws in the late 19th century is because they came far too late, and that would not speak to the understanding of our founders when they articulated and codified the First Amendment, which of course is part of the Bill of Rights, enacted in 1791, the same exact time as our Second Amendment. So anyone that thinks that late 19th century laws can cut back on our Second Amendment rights by creating some sort of historical tradition of firearms regulation need only look at the Espinoza case written by none other than Chief Justice John Roberts, rejecting 30 state laws in the late 19th century as not being relevant or helpful to understand the original understanding of the First Amendment, and they were rejected in upholding a free exercise law claim in that case of Espinoza versus Montana. All right, folks. Well, the bottom line here is this is great news. We are going to win this Reese case. I've said this before. I've said this on X at 4Boxes Diner many times. We are going to win this Reese case. The panel includes Jennifer Elrod and Judge Edith Jones and also Risa Barksdale. I think this is clearly going to be at least a very strong 2-1 decision. I think Judge Barksdale is going to come around and make it 3-0 is my guess, but only time will tell. Nevertheless, whatever happens, what I hope happens, and I have no control over this, but what I hope happens, and what we should be cheering for, is that the Fifth Circuit issues their decision on this Reese case very, very, very fast. It would basically be declaring that a federal gun control statute is unconstitutional, and then that the Department of Justice will really have no choice but to seek cert from the U.S. Supreme Court this term, and I think the Supreme Court will, there's excellent chance they would grant cert in this Reese case, and I think that would be very good for us because I think it will be another major win for the Second Amendment, and every time we can have a major win for the Second Amendment issued by the U.S. Supreme Court, it strengthens our hand and our ability to win for our rights and our freedoms. All right, folks, well, I'll keep you informed as this develops, but this is a great oral argument today. We are going to win this Reese case, and it's going to be a big win. I just hope they get that opinion out fast and they don't drag their feet, because that will give us a chance, meaning the Second Amendment community, a chance to get this case before the U.S. Supreme Court this coming term, 2024 to 2025, and not have it get kicked into the 2025-2026 term. But again, only time will tell, and I don't control these things. I only tell you what I think's going on and what I hope will go on and so on. Okay, make sure you follow me on X at 4Boxes Diner. Check out, by the way, if you're going to be in San Diego this weekend at the Gun Rights Policy Conference sponsored by the Second Amendment Foundation, feel free to stop by and say hello. I'll also be doing a book signing out there and 2 different speeches on different topics. So a lot of talking out there, and we will see you again either way here at the 4Boxes Diner.
Orders up. Table 2A.